name's Callum Nicholson. I was a Danube Fellow 2 years ago, or really until about 6 or 8 months ago. But today I'm here to introduce my colleague and friend Benoit Meyer, who's an associate professor at the Faculty of Law at the Chinese University of Hong Kong. So he holds degrees from the Sorbonne, from McGill in Montreal, and the National University of Singapore. And he's quite prolific. He and I began our PhDs at the same time, but since then he's managed to write 4 books, 4 edited collections, including the one on the screen. But he's second editor on that one, but the rest is all his books. And also 93 papers, which is an absurd number of papers of different sorts in the last decade, which makes me wonder what I've been doing with my time. But so Benoit and I got to know each other because we have a shared interest in the topic of climate migration, which is the subject of our co-edited book. I have always respected Benoit's work because he, in the topic we've worked on, I think he's the most, and he's going to not like the flattery here, but I think he's the most dispassionate, rigorous, and well-structured and tightly argued scholar in the field that I've read. And so it was a great honor for me when he joined the edited collection, which should be out in a few months' time. But also, I was delighted when he accepted an invitation to come here and to talk not about our book, but about some of his more recent work on climate change, the law, and human rights. So at this point, I'll hand it over to Benoit. Benoit will talk for about 20, 30 minutes. Then he and I will have a bit of a discussion. I have a few questions, and then we'll open it up to the floor. So thank you very much, and if we could all welcome Benoit. Thank you.
Thank you very much for the very kind introductions. So I'm going to speak today for about 20-25 minutes about climate change and human rights, trying to show what I call the elusive connection between the two. And then I hope to have some kind of dialogue first with Callum and then with all of you. So climate change and the law. So we all know about climate change is caused by greenhouse gas emissions. I'm not here discussing the phenomenon or the causes of climate change. I think science is relatively clear that our human greenhouse gas emissions are causing our climate to change. We have a 1.1 degree of warming in the global system. Those have important consequences for ecosystems and societies. Some species are disappearing, societies are being affected by an increasing frequency and severity of extreme weather events, sea level rise, and so on. What I'm interested in here is what we have to do about it. What do states in particular, because I'm an international law specialist, have to do about climate change? And there are 2 types of obligations that states have accepted since 1992, since the UN Framework Convention on Climate Change. States have accepted that first they have to mitigate climate change. That means that they have to limit or reduce greenhouse gas emissions, and they have to enhance the sinks of greenhouse gases like forest. So mitigating climate change is a global policy that states have to cooperate to do. If Hungary reduces their emissions, it's not benefiting to Hungary specifically. It's a global cooperation. So all states have to work together to achieve climate change mitigation. But states have also accepted that they have to help societies and ecosystems to adapt to climate change. We already have some diffuse impacts of climate change. And for instance, if we have more extreme weather events, then we can try to reduce the impact by taking disaster reduction policies. So states have accepted those 2 obligations. What I'm interested in my research, and especially today, is what exactly they have to do, states, on the mitigation of climate change. It's quite nice to say that states have to reduce their emissions, but by how much, how fast, by what time? And here I'm going to speak about whether the human rights law can be helpful in addressing this question. Most people have said yes, and I will say probably not. Most people have said yes. Most people have said that you can look at human rights law or you can frame climate change as a human rights issue, and it will help you to address climate change and to decide how to mitigate climate change. There is a very important judgment of the Supreme Court of the Netherlands in 2019 in the case of Urgenda against the Netherlands, where the court said that if you look at the court interpreted the European Convention on Human Rights, which of course applies to all European countries, as the source of an obligation for the state to reduce greenhouse gas emissions and to mitigate climate change. The argument was that climate change has impacts that affect society, including individuals. Those impacts affect our right to life because some people die in extreme weather events, and our right to family life. I'm not sure why. And on this basis, the court said that the state has to protect the enjoyment of human rights, and to do that, the state has to reduce greenhouse gas emissions. And the court went further and said that, in particular, the state has to reduce emissions by 25% by 2020 compared with 1990 on some, we can come back to the particular number later, but it's a very difficult conclusion to achieve. And this judgment has been extremely influential. There are now about a dozen cases, as has been mentioned in the introduction, pending before the European Court of Human Rights. A few cases have been rejected on procedural ground, but many cases are still being discussed. There were some hearing last week. There are also advisory proceedings before the Inter-American Court of Human Rights on climate change and before the International Court of Justice, based in part on human rights law as well. And there are many proceedings before domestic courts as well in many Western countries. Those cases often invoke concepts such as climate victims, climate refugees, and of course, as we mentioned before, Callum and I have edited a book on that, and climate disasters. And all of those concepts really assume that you can identify individuals affected by climate change. So this is the discourse I'm trying to question, and in my research I have been very skeptical of this discourse. I will present here succinctly three main objections to this discourse. The first objection is that, well, human rights law goes both ways. Climate change affects the enjoyment of human rights, but responses to climate change also affect the enjoyment of human rights. When a state is spending a lot of money on reducing greenhouse gas emissions, well, this money is money which is not spent elsewhere. And you could spend the same money on improving road safety, or in improving health systems or education, and those would also have some benefit for the enjoyment of human rights. Or if the state does not spend money but imposes regulation, then it also has an impact on people, because people have to comply with the regulation. And in a sense, it's also restricting human individual freedoms. Indirectly, it also has an impact on the enjoyment of human rights. So any regulation, any effort to reduce greenhouse gas emissions also has an impact on human rights. So if you want to justify the mitigation of climate change as a way to protect human rights, you also have to look at the other side of the balance, at the impact of such measures on the enjoyment of human rights. So if you want to look at climate change, climate action from the lenses offered by human rights law, you have to look at the cost and at the benefits of climate action, and you have to try to find the right optimum, the optimal action on climate change. And that's something that economists have been doing, except that they have not really reached any consensual conclusion. Some economists say that we should have 1.5 degrees of global warming. Some others say we should have 3 degrees of global warming. They disagree because they are comparing non-economic cost and benefits. They're comparing the cost of regulating the economy today with the long-term impact on human health, human safety, ecosystems over centuries. And economists can't have a very clear answer to this question. That's a very political question, how you balance our ability to spend money today to have cheap energy with the safety of humankind in 5 centuries. There is no objective answer to such question. So now, can human rights judges help to decide how to balance the cost and the benefit of climate action? I don't really see how they can do that. I don't see how human rights law can help to determine how far societies should try to mitigate climate change. The second objection I have is the scope of human rights law. So this is a very internal legal argument, but I think a very important one as well. If you look at human rights treaties, such as the European Convention on Human Rights, those treaties require states to protect the human rights of people within their jurisdiction. And the courts have interpreted the word jurisdiction as meaning effective control. So if you are within the territory of Hungary, the Hungarian government has to protect your rights. But if you are in Hong Kong, the Hungarian government does not have an obligation normally to protect your rights because you're not within the effective control of the government. Also, if you are not yet born, the future generations, then you're not a human being, so you don't have human rights yet. So now, most of the impacts of a country's greenhouse gas emissions will not be within the scope of human rights treaties. The emissions of greenhouse gases happening in Hungary have a global effect, mostly outside Hungary, and a very long-term effect, mostly beyond present generations. So the human rights treaties cannot really take into account most of the impacts of climate change that happen beyond the scope of the treaty obligation. So here we have to make a distinction between adaptation and mitigation. I presented the two concepts here at the beginning. So mitigating climate change is reducing emissions. Adapting is trying to deal with the consequences of climate change as it happens. Both adaptation and mitigation action have some cost. And if Hungary is doing adaptation and mitigation, the costs are mostly happening within Hungary because the Hungarian government will impose obligations on Hungarian companies and so on. But the benefits don't occur in the same way. For adaptation action, the measures that Hungary takes to prevent or reduce the risk of disasters, the benefits are in Hungary mostly. For mitigation, the benefits are mostly extraterritorial and the benefits are mostly on the long term. So looking at climate action from a human rights perspective will highlight the cost of mitigation action, but undermine or under-evaluate the benefit of such action. So I find on this basis that human rights treaties are not really pleading for climate action, rather to the opposite. Rather, they would be human rights treaties should rather be seen as an impediment to climate action, as a limitation to what the state can do to protect future generations and people outside the country. And the third objection is the fact that you don't really have victims of a state's lack of climate action. If a state is not doing enough to reduce greenhouse gas emissions, well, there is probably some kind of diffuse harm because you have more greenhouse gas emissions, you have more climate change, you have more harm generally. But you don't have individuals harmed as a consequence of the failure of a state to reduce emissions fast enough. So you don't have a victim. And I find it problematic to interpret human rights law as creating obligations for states when there is no victim. Because if you start doing so, then any policy issue, and I couldn't find an exception, could be framed as a human rights matter. Road safety, health, education, all of those relate to human rights. And you could go to human rights courts and say that the state has breached its obligation to protect human rights because it has not invested enough in road safety or not enough in education and so on. And the human rights courts will become the government. And nobody wants that. They don't have the legitimacy, they don't have the expertise, they don't have the competence. So there is a slippery slope here that if you start deferring to human rights courts to determine how best to protect human rights through positive policies on matters where you don't have a direct victim of the failure to take a policy, then there is a risk that human rights court will take over the government. There's also, it's a kind of a parenthesis, a procedural issue. Before many human rights courts, you will have to have the status of a victim, or at least a potential victim, to be able to have standing. And that's one of the main issues at the European Court of Human Rights in the present cases. But there are ways around this procedural issue. A number of states have a public interest litigation. Advisory proceedings before international courts can also evade this issue. So the procedural safeguards are not sufficient. I think the courts will also have to look at the substantive issue and what I call the slippery slope, that if you allow human rights court to look at would-be human rights violation when there is no victim, then human rights court will logically take over the entire government. So those are the three objections I have come to identify during my research. But they are quite obvious, to be frank. At least some of them are quite obvious. The lack of victim, I think, is something quite obvious. What I find surprising is that they have not really been highlighted by any colleagues. There is very little academic debate on the relevance of human rights law as the source of an obligation of states to reduce greenhouse gas emissions. Most of what you see published in law journals or books just avoid those questions, and sometimes in kind of bad faith. Sometimes I think there are some kind of double negations. We don't have any evidence that it is not possible, hence it is possible, which is a fallacy, of course. But sometimes just because the scholars who realize that there is an issue with the prevailing argument don't want to say it. They prefer to speak about something else. So there is really, for some reason, a lack of academic debate, a lack of people raising questions on those issues. And I think this relates to a sort of confusion at the moment, especially in climate law, between advocacy and academic research. Many scholars in climate law view their role as advocating for more action on climate change. And as a climate law scholar, I mean, of course, I went to the field because I was concerned by climate change. But I'm a legal scholar. I don't know more than anyone else about how much we should reduce greenhouse gas emissions. I'm not a scientific expert. I'm not an economic expert able to weigh the balance, the cost and benefit of mitigation action. I don't know whether states should do more. And I do not want to interfere with the political debate that should be had about finding the right balance between mitigation action and economic development. So there's a debate now on collectivism in law for a few years on the role of scholars in trying to steer political debates. And I think many colleagues believe that they can be both at the same time. They can be scholars and advocates, and there is no contradiction between the two. But I find, and I think this debate on human rights and climate change is an example, I find that by trying to do both, they do neither. They are neither doing rigorous scholarship nor doing effective activism. They're not doing rigorous scholarship because all of those objections are not being identified. And they're not doing effective activism either because, well, they don't really know what they are doing. They are not professional activists. They just have this vague assumption that if climate change goes to the court will do something about it, and the state will follow what the court does. But this is highly questionable. If the International Court of Justice was to tell states what to do about climate change, I do not believe that states will follow. So I'm not sure if there is actually a political pathway through human rights courts for enhanced mitigation action. So I'm highly skeptical of the effectiveness of the activism endeavor behind this debate. But there's also beside the effectiveness question, there's also an ethical question. Is it the role of scholars to try to manipulate political debates? And I use the word manipulate because scholars, when they publish something as scholars, are trusted by society, I believe, for trying to be dispassionate, or what some people would say objective, trying not to give their own voice, but trying to bring as much as they can the research of a rigorous, good faith endeavor to finding the truth. And the confusion between scholarship and activism is, I believe, a betrayal of the trust that society puts in scholarship. So that's my reflection. And something else I wanted to ask you is, how do you think scholars should engage with this tendency of confusing scholarship and activism, what we call collectivist? So should scholars try to reply to each of those arguments one by one? Should they try to show that there is some kind of bad faith, like attack the person making the argument as opposed to responding to the argument? Or do you think that the role of scholars is just to ignore this entirely and to focus on scholarship, ignoring entirely the phenomenon of collectivism? Thank you very much.
Well, can you hear me? Is that on? Good. Okay, so thank you very much, Benoit. So first of all, we'll have a bit of a discussion, then open it up to questions in 15 minutes or so. But the first question I have is, you talk about there being no academic debate, but obviously in making this sort of argument, you are in a sense provoking a debate. And I'm wondering, first of all, how is, or indeed how would, I don't know how new it is for you to be stating this argument, how is or how would your argument be received by climate law circles? Would they criticize it? Would they simply ignore it? Would they accept it? How do you think you'd be received, or the argument be received?
Some of this presentation has already been published. The second objection on the scope of treaties is published in the American Journal of International Law in 2021 or 2, and in a book. And it has been, I think, the best example I have to answer your question is the European Journal of International Law recently published another article by a collectivist a few months ago. And I'm not sure how much I can say in terms of the actual process, but it seems that the first submission to the journal did not mention my article. It was the reviewer asked for it to be mentioned, and the final version had a paragraph in the introduction mentioning my article, saying that there are many objections, however, those are not impossible to address. Double negation.
Not possible or impossible?
Not impossible to address. And then moving to something else.
So they didn't address them, but they said...
They identified them, but they asserted that they were not impossible to address.
Do you? I mean, so we've worked on the same topic for a number of years. You've moved on to other topics, but we were looking at climate migration, and the pattern you've described is one I noticed as well. But what is the pattern of responses you've seen with? I mean, for instance, there people acknowledge there is a critique, but they don't actually answer it. I mean, how do people? That's always struck me as a strange response, just to not actually engage with the argument. Why do you think that happens?
Why? I mean, I can only speculate, but my speculation is that there is an agenda, and the person who wants to write something. I mean, there are two possibilities, right? One is the bad faith. Like, I know that my argument is wrong. I don't want to acknowledge it, and because I have some political stakes in the debate, and therefore I will just try to evade it as far as I can. But I think there is something probably more likely to be true, and we discussed that before with Kalum. I mean, and I did the same. My first publication, when I was still a master's student, was on climate migration, and I put everything that I've been then opposing in the next 10 years. Like, we have to have some protection for climate refugees and so on. And when finishing the paper, I realized that the argument was based on questionable concepts. But I had to choose. Do I want to publish it or do I want to not publish it? Basically, because when you're already very far in a research project, you can't really change everything entirely without losing the publication. And I had some career interest as well in publishing it. So it might also be a trend. So it might be some people who, from the start, know that their argument is wrong and don't really care because they just care about converting people to a political cause. But there may also be a sociological side. Like even if you know that your argument is wrong, you don't want to acknowledge it because you want the publication. And of course, the entire academic system is based on number of publications, which, by the way, you should not mention because it's really not so flattering. So the number of publications is really valued much more than the coherence of those publications.
So a related comment, which you've partly addressed, but when you talk about collectivism, I'm really wondering where it comes from. But I also want to be devil's advocate against us both, because I think we both agree that it's quite bad. But I wonder, is that simply because we're relatively young compared to, well, not everyone, but certainly some scholars who are older than us. And I wonder, is it that we are noticing it more now because we are more in it professionally, and we don't remember what it was like before? In a sense, was there always collectivism? And if not, why is there so much? What are the incentives to do that? You've touched on it a bit, but it seems to be not just this topic or climate. There's a lot of what we might call collectivism going on. Why do you think that is? And is it, in fact, worse? And in a sense, also, what have we forgotten in that? What has been forgotten that used to be central to education, central to research, which has been lost?
Yeah, it's a very good question. So I can't really comment on the historical trend because we are too young for that. But I mean, it's a very important question. My guess would be that it's at least not necessarily a new, but a more important issue today than it was 10 or 20 years ago. And for the same reasons that we have, the echo chamber phenomenon on Twitter, that people are being served what they want to hear, and that new technologies allow that. I suppose that 20 years ago, people would be more likely to read the leading journals in their field. Today, people are more likely to Google something, or a scholar Google something, and to find the piece somewhere that supports whatever argument they want to make. Well, we have seen that on, I have some example in my mind about climate migration, of people having this argument and trying to find the evidence, as opposed to doing the other way, like starting with an open mind and trying to look at what has been published. And new technologies facilitate the trying to find evidence to support your assertion, and possibly publications are adapting to that with some publications may be focusing on a particular trend of collectivism, and so there might also be some kind of echo chamber in academic publications.
So
if I think there's also a failure of the peer review system. I mean, I'm not sure if it's a new trend actually for that part, but we often believe that the peer reviewers in academic publications, who are supposed to be the gates of publication, of academic publication, they're supposed to prevent this kind of issue. But I mean, as a journal editor, sometimes you will try to find the favorable reviewers, and if the reviewers are, have published on climate change and human rights, very likely they will be in favor of the prevailing argument. So if you are opposing the prevailing argument, then you have a much stronger way to go. So my research on the topic could not possibly be published in low-impact specialized journals. It can only be published in high-impact non-specialized journals because of the peer review system. And that's very weird, because normally those journals are much more competitive, but actually for this argument, they are much more open.
I should say on that, I mean, I've noticed myself there's been a proliferation of journals, and if you actually get to understand the politics of a lot of journals often, and not in all cases, but I certainly can think of examples where journals, there's a bunch of mates basically who seem to publish each other and review each other for the same journals, which is very niche. So it's only they contribute and only they seem to read it. And it's kind of like crypto. There's just thousands of cryptocurrencies now, which is interestingly similar because the legitimacy of academic knowledge is supposed to be in the peer review system and citing previous papers. And it's kind of like blockchain is about peer-to-peer, and it's got this hash of every previous block in it. But if you just proliferate, cryptocurrencies are worth nothing. If you just proliferate journals, it seems very similar. It's my own theory. But an additional question for you is, you mentioned about there being sort of no victims and the slippery slope argument. And I've seen some scholars recently talking about a need to reconstitute or reconstrue deprivation as persecution. So there's a distinction, which I believe is a legal distinction. So a refugee is someone fleeing persecution, whereas an economic migrant may be fleeing deprivation, poverty, but that isn't the same thing as someone, the fear of the state coming around at midnight and kidnapping you. It's a different experience. But some scholars on climate law, I know, have been saying what we need to do is take deprivation in the context of climate change, reframe it as persecution, so that there can be some sort of refugee protection of, say, climate migrants in this case. What do you make of that? Is that an example of slippery slope? What do you make of that tendency to shift now, or that impulse to shift from persecution to deprivation, or deprivation to persecution?
Right. So, there are two questions here. One is about human rights, one is about migration. So I will respond to human rights first.
Yeah, I suppose, yeah.
Right. Human rights treaties have long been interpreted as creating two types of obligations: to respect and to protect. Negative and positive obligations. So negative obligations are like not ringing at the door at midnight to like put someone in jail without a due trial, a due process. And that's something that dates from the French Revolution, for instance. But for a few decades, like since the mid 20th century, there's also been a clear recognition that states have positive obligations to take measures to ensure that people have education, that roads are safe, that crimes are punished. And this is not just economic and social, it's also civil and political rights, like the right to life is not properly protected if you don't have a crime of murder and investigation when something happens. The issue with the positive obligations is that they are resource dependent. Right? If the state has very little money or very little capacity, they can't really protect it well. Whereas respecting rights is easier. You just don't do anything and you respect rights. So you can't have a proper due process, a fair trial, if you don't have a court system. You can't have a court system if you don't have the money and the resources to establish a court system. So that's something that is well established. I'm not criticizing this. I think states have to have positive obligations to protect human rights. This has, however, to be limited, and they cannot be. We cannot interpret these positive obligations as expanding to any policy matter, because otherwise human rights courts become like a new government in power. And my understanding is that the limitation should be when there has to be a victim or someone who could possibly be a victim, or there could be someone who would be identified as a victim if the state does not do something. So if the state does not establish a court system and someone is murdered, then the next of kin could say that they don't have a right to fair trial because the state has not taken the measures they should have taken. But if the state does not establish does not adopt sufficient measures to reduce greenhouse gas emissions, then there's no such victim. So I think that would be one of the ways to avoid the slippery slope. But the second part of your question is also very important. In what case should state offer protection? Only when the state of origin is persecuting by taking measures to persecute, or also when the state is failing to take measures. So refugees protection has sometimes been applied when the state was failing to take measures to protect particular groups within the country from private violence. There are a few cases, but usually in the existing state of the law, it has not been applied when for the failure of a state to take measures to protect people. And well, I think there is a strong argument that humans have dignity and that should be protected. At least I believe in that. That's where my values enter into my reasoning. I think there is a strong argument for protecting forced migrants, even if the cause of migration has nothing to do with state persecution. But this argument should not be limited to climate change. It should be open to every single cause of forced migration. So if people leave because of famine or because of violence or because of drought, whether or not related to climate change, I think there is a moral argument that we should try to find some way to help them. But it's not about climate change. It's about what Alexander Betts calls survival migration. There is an issue, a political issue with addressing survival migration, but this has nothing to do, or it should not be related to climate change.
I have noticed sometimes when people talk about climate refugees and fleeing forms of deprivation, that I do wonder why, not so much why they've expanded it to include climate, but why are they limiting it to that? Because if you're worried about deprivation, as you say, there are many forms of deprivation. Why don't other people qualify? Why simply from climate? Presuming you can even identify climate as a cause, which in this very good book you can discover there are many objections to that. But so another question for you about, as we mentioned, the causality there of between understanding the impact of climate on society. Implied in your discussion, I think, and in your work in general, is raising a problem of generalizing from the science of climate change. Because it seems to me certainly that when we talk about climate change, we aren't just talking about the science of climate change. There's a context to that. We're thinking about its impact on people. That's why we care about it. But I sometimes wonder if our understanding is less informed by a rich understanding of science, so much as an impoverished understanding of society and people. And I'm wondering what you think about the role of science in the debate about climate change, the status we give science in the discussion, and are we in a sense too preoccupied with the science? I'm not saying to dismiss the science, but is there more to the problem than simply a scientific question?
I agree. There is a tendency in climate law debates, including judicial proceedings, to allude to science. And very often we don't even know what science it is, if it is physical science or economics or social sciences. For instance, I mentioned the case of Urgenda in 2019, but 2 years later, the Dutch court in The Hague ordered Royal Dutch Shell, the oil company, to reduce their CO2 emission by 45% by 2030 based on tort law. And in this judgment, the court mentions that the 2 degree or 1.5 degree target of the Paris Agreement is proven by science, which makes no sense, because science could not possibly tell you what to do about climate change. Physical science will tell you what's happening when you put CO2 in the air. Economics may tell you how to value different phenomena under particular assumptions, but none of them will tell you how we should decide how to balance the costs and the benefits. There is a political question, and that's often hidden behind some kind of allusions to science. And that's very preoccupying. Everybody believes that they have the right understanding because they read some science. But they don't understand that there is something between science and their political argument. And there are some values, there are some ways of balancing different costs and benefits. And we basically lack a political argument. Because we believe that science will determine everything.
It's interesting that in your discussion you talked about when people talk about, I think it was your second objection, people forgetting the context of the state, and you've just mentioned now that people forget there's something between the climate change, the science of climate change, and their particular politics, and I can understand how a lot of people who are not lawyers forget that we're not just operating in a vacuum when we do anything. We operate in the context of a nation-state system, particularly institutions and so on. What I'm really surprised about is that legal scholars are forgetting this. And do you think they are? And if so, why?
I think yes, there is. So human rights treaties are very clear for most of them on their territorial scope, and you cannot. I mean, there are ways of interpreting treaties, and you cannot interpret a treaty without looking at state practice. And don't tell me that states are protecting human rights globally without preferring their own territory. I mean, any state practice, look at the COVID vaccine or at medicine education. Any country invests more in education territorially than extraterritorially, right? So obviously, human rights treaties are territorial or mostly territorial treaties with a few exceptions of, okay, if the UK sends a soldier in Baghdad and the soldier kills someone under the order of the government, it's an exception. It's extraterritorial, but it's human rights. But yeah, so I think why do legal scholars forget that? I think because they have political aims. They are approaching the question with, they know what the last line, the conclusion of their paper will be, and their attempt is to find a line, a thread of arguments from the introduction to the predetermined conclusion. Whereas I think a scholar should do the other way. We should never know what is the conclusion of our paper when we start it. Otherwise, we are just wasting our time.
I often felt that with the climate migration debate, because people would say our paper is to discover what climate migration is, but in calling it climate migration, you've already asserted what you think it is, which I always thought was a funny logical problem in a lot of the papers. So a final question from me, and then we'll open it up to the floor and any other questions, which is that obviously the debate around climate change is very political. There's often this discussion of believers and deniers. Now, personally, I've always found that a very irritating distinction because it implies you either agree with everything and the consensus, or you're a denier of all these things. But it always struck me there was less of a believer and an atheist position, but a slightly agnostic position, perhaps, of saying, let's assume the science is accurate and so on. The question is, in a sense, so what? You know, there's the old university essay question, what is gained and what is lost when, in this case, we privilege climate change in our understanding of human problems. And I wonder that, thinking about your presentation, you make this distinction between the question of whether to mitigate to the question to shift to how to mitigate. And I wonder, do you think the prevailing political polarity to the discussion of climate change is inhibiting important debates about practical implication, the question of how? Do you think there's a need for us to find a way to talk about climate change that is not always haunted by this very binary politics?
Yes, I think there is a need to look beyond the assertion that more is needed all the time. What I found, so I think you make a very good point, like the binary sort of logic, you're with or you're without, you're a normal person or you're a climate skeptic or denier is the same. And I mean, I think that there is a continuum of views. There are people who believe that there should be more mitigation action, but there should be questions of how much more. Very often in climate law scholarship, what I see is absolutely no mention of the cost of climate action. How can you discuss the need for climate action without mentioning the cost for climate action? And this argument I made about you have to look at the human rights cost as well of mitigating climate change. I mentioned that in one conference one time, and someone who had been writing on that for very long responded, I never heard that climate change action could have an impact on human rights, or negative impact on human rights. I don't think you can prove that. And I mean, that's obvious. If the state is spending, like we speak about 10 billion, there's 100 billions of dollars per year at the global level, I mean, how can this not have an impact on human rights? So there is a sort of isolation of, I think some people live in a small bubble in like the Netherlands or Western European countries and are not really exposed to any critical argument. And I believe that the echo chamber is part of the issue here, like the way that social media and media generally are kind of compartmentalizing the debate, and you're only exposed to the arguments you're comfortable listening to.
So on that note, so we're not subject to the arguments that I'm comfortable saying. Can we open it up to any questions from the audience, please? Go ahead at the back.
Tree programs everywhere, because tree programs, it would reduce heat, noise, pollution, dust, create shadow, put them on the motorways, put them in the shopping centres, put them on the promenades. I think that would be a solution, I think, at least part of it. It's just an observation, that's all. Thank you.
Thank you.
I hope it has some value to this.
I don't know about Benoit. I mean, I'm always for more trees. So.
Yeah, I mean, there's clearly a bit of greenwashing when you see a new airport with a row of tree at the entrance, give you good conscience to fly around. But yeah.
I think, I don't think we disagree with the importance of trees, of course, but I think there is something Benoit just raised, I think is a very important point to make that comes out of that, is that while obviously planting of trees and maintenance of the environment is of course helpful, not simply for climate, but I think also for community well-being, for many factors, in a much more proximate sense of just good neighborhoods and so on. I think the point about greenwashing is important because often what we see are proposals made that are classified as green proposals, and we have to be quite skeptical, I think, sometimes about the performativity of that sometimes they're presented to give a good look to something where there's other problems or other trade-offs. But in principle, I don't think, that's a good point.
Hey, that was great. Thanks, professors. Who has standing in front of the court, and how are the judges chosen? And is there such a thing as mitigation or impact statements that are allowed to be admitted? So you were talking about, if you do X course of action to try to resolve the injury, what is the fallout from that? Is that able to be? Can a country being sued who's being required to perform actions to eliminate the damage, the cause of the human suffering, is there some kind of economic or impact statement that is able to be submitted as evidence?
That's a very good question. So it all depends on the court. So different courts will have different procedures, and I'm not really an expert in judicial procedure, but there is a huge conceptual issue with having a political public issue pleaded before a court as a private case between one individual or one NGO sometimes. So it depends on the court, and sometimes one state, sometimes one corporation. I will give you an example. So imagine it's totally possible for one NGO to sue one state before the European Court of Human Rights based on some kind of arrangement between them two. Let's say a very green state. I'm not sure what green state there is, like Slovenia, for instance. Just imagine. Imagine like an NGO, Greenpeace, suing Slovenia before the European Court of Human Rights. Both of them have an arrangement that Slovenia will provide a very weak argument before the court, so that the court decides in favor of Greenpeace. The court will order Slovenia to do what Slovenia is already doing, but it will create a precedent that will bind not bind, but that will be almost directly applicable to any other European countries. So you have a public effect from a private litigation, it's not private, but from a litigation between two persons. And that's really a big issue. And there is no safeguard before, to my knowledge, any court to avoid that. And so that's really an extreme case. And if it did happen and there was an arrangement between the two parties, the court will find that there is no actual dispute. But there could be something in between, right? And something actually very close to that is the current adversary proceedings before the International Tribunal for the Law of the Sea. That has been requested by a small organization called the Committee on the Law of the Sea and the Effects of Climate Change, or something like that. There are 3 state parties, Palau, Vanuatu, and Antigua and Barbuda, so 3 very small island states, all of them very much concerned by the effects of climate change. And they request an advisory opinion of an international court. The advisory opinion will be listened to by every court in the world, to some extent. I'm not saying that every court would follow it, but it will have an influence on every legal system and on other international courts. Now, it's not really clear at the moment, to me at least, which state will be allowed to submit their views to the tribunal, but it might be that only those 3 states will be able to provide their views. And in that case, the tribunal might be extremely badly informed about the consequences of their judgment. So there is really an issue of, what are the submissions before the court? Who is able to plead before the court, and is the court able to look at the consequences of their judgment? Very often, so it really depends on the court system and so on, but very often I think the court will be badly informed because the questions are extremely complex. I mean, economists have been debating for decades about the optimal level of mitigation action without them reaching any agreement whatsoever. I don't know how a court could be expected to come to a conclusion. 3 or 5 or a dozen legal experts with no scientific background, for most of them at least, looking at, for domestic court, hundreds of cases at the same time, spending 1 or 2 days on piles of documents. There's no way they can come to any rational conclusion on that. I'm not sure if I responded to your question entirely.
Thank you. John.
My question, I'll put it this way. Who has standing to write in law journals on this question? The reason I put it that way is because presumably the technical answer to that is anybody who's reached a certain level of eminence in the law, either as a practitioner or as an academic expert. But I think we both know that is not the real basis of standing, because at least in scientific journals, and there have been a number of cases of people, well-recognized, well-credentialed academic experts, scientists, who've presented articles to magazines like Science and Scientific American and had them turned down on the basis that it would encourage belief in a certain outcome, namely that climate change is less serious or that there are other methods, that adaptation is a more sensible method in mitigation, these kind of things. And so their arguments, in a sense, in practical way, are denied admission to the what is generally understood as the arena of public debate on that issue. And why is that? I have ideas on that, but yours are the ones that count here. And what can be done to ensure, as far as possible, a level playing field? And what criteria would you have to judge whether or not a particular kind of argument could be presented?
Well, it's a very difficult question. Callum. I don't know. I mean, why is that? It's because of the peer review system, I believe, because there's a tendency when you peer review a paper, if you disagree with the conclusion, you will probably disagree with the paper being published, and especially if you are a collectivist and you believe, as you said, that the paper will have a bad influence on politics, and you don't want that to happen. So I'm not as categorical as you in terms of saying it's not possible to publish. I think it's possible, but not in every forum. Like Nature, climate change, no. But the American Journal of International Law published some of these ideas. I had to twist the paper a little bit under the influence of one reviewer. The conclusion I wanted to arrive at was you can't apply human rights treaties. The conclusion I had to publish was you probably cannot. It seems very difficult. Perhaps you can. I had to add the perhaps you can to have it published. But I think if you read between the lines, you see the real thesis in the paper. But I think at some point you have to compromise a little bit, unfortunately, even if you have to compromise on the where you publish and how exactly you frame the argument, how you present it. So how to address this problem? I have not thought about that very much because I don't think it can be done. I think there should be some better. I mean, it's a matter of ethics of peer review. Well, to my mind, I don't think we can do without the peer review. Editorial ethics, not just the peer reviewer, also the editor of the journal. Right? I had one paper actually where I had 4 reviews. 3 of them were extremely positive. 1 of them was negative and ungrounded, in fact, and the paper was rejected. And I know this journal publishes papers that have 3 favorable reviews out of 4. So the editors also have some leeway if they don't like the thesis, and I find it very unacceptable. I think that there should be some kind of research training for. We don't have any training as a peer reviewer. We're just training doing research, or kind of. And sometimes we receive an email, can you peer review this paper, without any kind of background? Some people look online and there are some materials, but we're not really told what should we or should not take into account in peer reviewing a paper, or what we should or should not accept as an editor of a journal. And I think that there ought to be a debate among scholars about, first, the role of scholars, whether or not this is the same as the role of activists, and second, how to decide what to publish, on what ground to reject a paper. And that's something that is kind of missing at the moment.
I'd just add to Benoit's thoughts there that I think one thing is that there's not really training given to academics about how to peer review. You kind of pick it up along the way. But I mean, maybe your institution was different. But most people, I don't know anyone who's had formal training in it. And you can get, I've seen peer reviews, not of my paper, but I remember there was one paper I was asked to peer review it. And when you peer review, you don't want to not say what you think, but you try and couch it as courteously as you can, because you don't want someone to be psychologically damaged from the criticism, right? So you couch it as best you can. I remember reading one where this other guy was reviewing it, and he was quite vicious, actually, quite vindictive. And I also didn't like the paper, but he was really quite vindictive, and I felt that's not helpful. But it's often more present when you have this sort of scholar activism in reviewing. Another thing that's quite interesting, I've noticed. There was a paper I once reviewed where the other 2 reviewers accepted it, and I had major objections. With reviewing, you typically can have major or minor objections. Minor is the sentence, fix it, a couple of problems here, add a few references. Major is just the entire thesis I think is flawed, it's incoherent. And now the judgment shouldn't be whether you disagree with it. I've accepted stuff I disagree with, but I think are well argued. I don't like it, but it's a valid argument. The problem is if it's just massive internal inconsistencies. That should be the basis of a major objection, I think. And I remember one where the other 2 accepted it, and I had major objections saying it needed to be revised in its current form, and it was published as it was. So they ignored my major objections, and the other 2 had minor objections, and it was published with a few minor changes. But then I was in a position where I had a review where I had someone have major objections to my paper, which naturally I thought were unfounded in this case, and I liked my paper, and I may have been wrong. But what was interesting was that that one was, even though the other 2 accepted it with minor changes and one person objected, mine wasn't published. Now, the fact is mine is neither here nor there. The point is, when the argument is for what seems to be the prevailing agenda, if there's major objections in 1 and 2 accepting, it'll be published. But if it's against the mainstream of something, against orthodoxy, in my experience, there is sometimes a tendency that simply one person objecting to it is enough to sink the paper. And I think there's a certain there is a whole question there of the ethics of peer review. But peer review, in my experience, and I don't know what yours is a bit of a wild west. There aren't really clear guidelines, and I think it would be I'm not sure about criteria for peer review, but I certainly think there should be some sort of training in how to be courteous and stay on the topic. And to be founded in the criticisms, because sometimes you get people reject things based on a total misreading of the paper. And I've seen this in papers of mine. I've seen it in papers I've myself reviewed, and I've seen the other reviewers who've totally missed the spirit of the paper. And indeed, when I review, sometimes you have this fear, I think, when you're reviewing someone's paper, thinking, especially if you're critical, you wake up at night thinking, did I miss the point? Was I fair? And I wonder if everyone has that feeling. But please.
On that point, in a way, wouldn't it be, and maybe something like this is done, but I don't know about, wouldn't it be fairer if the peer reviewers or peer reviews were all published? And then we could see for ourselves whether or not the criticisms mounted of the paper were fair, unreasonable. And sometimes, of course, the result might be very humiliating to the peer reviewer, which would, I think, therefore, an incentive to make sure he does the real work on the paper.
I guess to say quickly on that for myself, that I think there's something in that. I'm not sure what Benoit thinks, but certainly the person I'm thinking about who was quite vindictive in their comments did it so behind the veil of anonymity. That it was not the person they were reviewing didn't know who they were. I could see who they. Actually, I don't even think I could see who they were. I just saw it. I saw the comments, and it was. So I think that there would be an incentive to be a bit more civil. It's like social media. People are mean online usually because they're on an anonymous Twitter account, right? If you know who you are, then you're more likely to be courteous. I think that would be one factor. But I also think the problem, there's so many academic papers now in journals. Often papers are not responded to. Often one of the problems is if you are criticizing a field, people can just ignore it. They can ignore the criticism. And I do think the people who will read it most closely probably are the reviewers. There's something in publishing it, I think. I don't know if you agree.
I think anonymity is really important for peer reviewers. If it was not anonymous, I would probably not review a quarter of what I review because, I don't want to make enemies. Nobody would want to openly criticize a paper and say it shouldn't be published. So anonymity is really important. It's the only time as a scholar where you get frank feedback on what you have written. And that's extremely precious. That's what I prefer in the world of academia, really. However, having it published would be useful in a sense that it would put pressure on the editors. And I think the editors have a lot of responsibility in that as well. I'm co-editing something at the moment, and don't want to say too much, but we see sometimes like reviews that say reject. There is a typo on the third line. And that's it. Okay, the typo we can correct. And then we see reviews that say, okay, all this problem, the concept makes no sense. I have no idea what they talk about. Minor revisions. So you cannot just look at the conclusions. You have to look more into the details. A few weeks ago, we had a paper that had two reviews. One was reject on almost nothing, and the other one, reject with a lot of comments explaining why, and the other one was saying, I like the paper and no other comment. When there is absolutely no comment, my assumption is that the reviewer has not read the paper, because you can't read 20 pages and not find one typo or one thing you don't like, or one reference missing, or one thing to notice. So the editor has a responsibility, and very often editors don't want to assume this responsibility, to look at what kind of trust you can put in this reviewer. Some reviewers will always say accept, some will always say reject, but you have to look at the reasoning behind that. And so having as some journals start doing it, I think, having the text but not the identity of the reviewer published. But then you still have the issue of the rejected papers. How do you do it? How do you put pressure on the editor not to reject a paper on political ground? Because you couldn't publish the review without publishing the paper.
Is there something implied, though, in all of this, though, which I think is that I think this comes back to the status of science, because I think sometimes in a non-scientific or non-academic context, there is an assumption that science is almost like the scientists and scholars are like a priesthood with access to the mind of the truth, if not God, and that they are dispassionate and so on. But it's just as human an activity as anything else. Editing and peer reviewing and indeed writing these things is much subject to politics of the politics of incentives and so on, and the fear of failure, the fear of offending your colleagues, which is sometimes the same thing if they got control over your career path. There are all of these issues, and I think the issue for me is less that the science has problems and is political and human, but rather that sometimes in society there's an assumption that science is not. That seems to be the more dangerous assumption. I don't think science can get better, but we live in an age where we think it is better than it is, and that's the problem, I think. Any other questions? How much time have we got now? One more? Yeah, one more question maybe, or.
I have a question, if no one else has one, directly arising from your paper, which I very much enjoyed. But you're pointing out at some point that the barriers of the divisions, the borders between different topics were being eroded here. The human rights and climate, they don't really go together in quite the way. Now, maybe I'm wrong about this, I've got two experts, but the advance of scholarship, science, but other forms as well, has been essentially based on establishing boundaries between one area and another. If it's geography, you're dealing with geographic things, and if on the other hand so geography isn't law, and law isn't science, and so on and so forth. And yet, isn't a great deal of the debate, as it's that you're describing, and in other areas too, based on claims that erode or completely erase barriers between one form and another, the one topic, one area of scholarship and another? The case I would cite is the doctors in radical left organizations who claimed that racism was a health issue, which gave them a particular authority to pronounce upon. If you remember, they decided that, among other decisions, they decided that to gather during the pandemic in large crowds was always wrong, except if the crowds were protesting against racism, because racism was a health issue. And therefore it was, in a sense, it was presumably an extremely odd cost-benefit analysis was involved in arranging that. But that's the most extreme version. But another would be the argument that words of violence and violence, however, is a form of words. All of those arguments seem to me to attempt to erase standards and borders, which in the long run makes any real development in science or other forms of scholarship extremely vulnerable.
Yeah, I fully agree. I think that, so as a climate law scholar, I keep being asked, people assume that I believe that we should enhance our action on climate change. And so I can't say that, because the test I always try to keep is, can you demonstrate that with the methodology you know how to use? I'm not an economist, so I can't answer an economic question. And it's a matter of humility, perhaps, of epistemological humility, of knowing what we can or cannot demonstrate. I have many things I believe, and when I vote, I use that. I believe we should have more climate action because I'm really concerned about the long term, but that's not something I can demonstrate. So that does not inform my scholarship. But that's very old-fashioned, and the new fashion is, there is one way of thinking: we should have more climate action, and writing anything differently is, unacceptable, and that's really concerning.
Yeah, I'd agree, and I also think that one of the problems we see across a lot of areas of knowledge now, and indeed action, is that we have, I think, we talk about pandemics. I think there's a pandemic of hubris across lots of areas, and we as opposed to humility. I think sometimes humility is having the courage to say you don't know something. And I think a lot of what we've done, if just to bring it back to our lovely book here with a great cover, with a great metaphor that you can discover if you read the book. With the book, I think what we were trying to do in this book was to advocate not for any particular answer or anything, but the humility to ask more questions of ourselves as much as other people when we think about these topics. Because it seems to me that when we look at topics like climate migration, certainly my motivation in us putting the book together was to was because a lot of the patterns and problems we see in contemporary society, you see distilled and concentrated in a quite narrow debate around climate migration. Assumptions about what we can know, what we ought to do in the face of what we believe we know, and so on. And I do think there's a lot of hubris, and we could do with a little bit more humility. This book is largely an effort to encourage people to have the humility to not just think they can answer the question, and indeed to advocate for a particular answer, but have the humility to question themselves, to have that reflexive capacity, which is something I think we both think is missing in a lot of contemporary debates on these sorts of issues, be it law, climate, migration, human rights, and so on. And I have other things, but I should probably stop there. But if there's no more questions, any more? One more, very quickly. Two more, yeah. Just wait for the mic, and then one, and then two, and then we'll have to cut after that. Thank you.
How do you feel about the international judiciary? Are they pre-committed to this narrative that clearly academia and the governments are, or do you find that they're open to debate or papers and arguments like yours?
Thank you. I think it differs between the different courts, right? So there is the European Court of Human Rights that I think would be very sensitive to the last argument, the slippery slope. I think that would be the main thing. They don't want to lose credibility. They don't want to replace the government, and they hear, the critics of the court in the UK or in continental Europe increasingly. So I would say 70% chance all the cases will be rejected, possibly on standing, or not, possibly less likely on substance. I think they would prefer the standing because it's easier politically, but we will see. Where I'm more concerned, and there might be a positive judgment, would be the Inter-American Court of Human Rights that loves to have very liberal judgments, and the other one is the International Tribunal for the Law of the Sea, which has very few cases and has to justify their budget. So they are very happy to receive a case. I mean, literally, it's an empty building most of the time, and there are 20-something judges, and a huge building in Hamburg. So those courts will try to do something with it. I don't know how far they will go, but they will try to. Then, where I really don't know is the International Court of Justice. Most likely, the timing would be very important because all of this happened at the same time. And it's likely that the Inter-American Court, the European Court, and the International Tribunal for the Law of the Sea will make decisions before the International Court of Justice. And that means that courts tend to follow each other. They don't have to, but they tend to follow each other. So it will be more difficult for the International Court of Justice to reject the advisory opinion after the Inter-American Court and possibly the Tribunal for the Law of the Sea have given expensive advisory opinions. So I don't know, really. That's concerning because I believe that the ICJ, the International Court of Justice, can only do harm on the question. They can't do anything useful. They can only do things that are counterproductive.
And one final question here.
Good evening. My name is Lily Tanui. I'm from Kenya and I'm studying here, environmental engineering. I have a question about victims because you said that there are no victims of climate change, but where I come from, farmers could have plants and animals could survive, but lately animals are dying, people are also dying because of climate change. Then are these not direct victims? And I have also one more question. You said that people should not say this as just climate migration, but see it generally. And don't you think by doing this, we will be denying it the urgency that it needs? Thank you.
Yeah, thank you very much. So that's really the issue of the causal link. So let me just clarify. The argument that I'm opposing is not, as it was often framed, and as I did frame it to make it simpler, I'm not objecting to climate victims. I'm objecting to victim of a state's failure to take mitigation action. That's what matters before a court, because you have a case against one state, and you have to explain that you, as an individual, is a victim of that state's action. So you have to show, let's take the causal link. You have to show that the failure of a state to take more action to reduce their greenhouse gas emissions has caused an impact on the atmosphere that is such that there is an individual affected. So we're not looking at the emissions of the Netherlands, 0.5% of the global emissions. We are looking at the emissions that the state could have avoided by taking measures in the last 10, 20 years. So perhaps 10% of those emissions. So it's 0.05% of global emissions. And so this is a very, very small part of climate change in itself, right? Because most of the emissions today cannot be avoided, I mean, on the short term, without destroying the entire economy. However, you assess the obligations of states to reduce their greenhouse gas emissions, it's not an obligation to stop greenhouse gas emissions. And then on the other hand, you also have the long-term effect, right? Like the measures that the Netherlands could take today or in the last 20 years have very little impact today. They have an impact in 50, 100 years. So the drought in Kenya is not really caused by the failure of states to take reduction emissions measures in the last 20 years. It's caused by 2 centuries of action. Most of them happen without any knowledge or without any capacity to reduce emissions. And then on the other hand, the actual harm that herders or nomads are suffering depends also on the policies adopted in Kenya. I did a field work in Mongolia, and I looked at migration in Mongolia that were triggered by some climatic effects. And what I showed was that it's mostly public services. The 1990 reform basically stopped most of the public services in the countryside. People therefore have to try to live close to the town. They concentrate. There's not enough grass at the place where they concentrate. And they want to be close to the town because they want their kids to go to school and to have the pharmacy and the doctor and so on. And therefore they lose their herd when something happens with the climate and they have to move to the capital city to try to find a job. So the climate is part of the equation, but it's only a very small part, right? There's so many other things. And of course, the government will say, this is the climate, this is not us. And this is very acritical of scholars to accept that. I think we have to fight back and say, there is something called disaster risk reduction. And that means we can do something against disaster. It's not natural, it's not climate, it's largely policy at the place where it happens.
Can I just add to that very quickly that obviously there's been this terrible earthquake recently in Turkey, and it reminded me of when we saw the buildings that collapsed. There's been a lot of discussion about failure of building regulations and so on. A lot of the buildings were top heavy. They didn't have a ground floor that was secure. There's a particular type of building that was very vulnerable to collapse if there was a bad earthquake. And there's actually a phrase that is very common in disaster risk reduction scholarship, which Benoit mentioned, which is this, and it's well known because it's quite a striking phrase. It says, earthquakes don't kill people. What kills people is collapsing buildings. And the point of that phrase is that the thing that determines the societal outcome is not purely or simply the magnitude, in that case, of an earthquake. It's to do with a whole range of other factors. There's a very famous paper from the mid-90s, I believe, by Anthony Oliver Smith, where he wrote about Peru's 500-year earthquake. Now, the 1970 or 71 earthquake in Peru was very, very high on the Richter scale, killed 70,000 people, left several 100,000 without homes. But he said the earthquake may have lasted 60 seconds, but he said the conditions that led to the vulnerability of the society went back 500 years to the beginning of Spanish colonialism. Before Spanish colonialism, the Andean cultures there were very adapted to the prevailing context, which was very subject to earthquakes. They were so adapted, they didn't build walls with walls that were wedded together. They had them tied together so they could move. They didn't use tiles, they used thatch so it wouldn't fall on your head. They had storehouses of grain in case the community was hit by an earthquake. And they didn't build cities in places like Arequipa, which was very subject to earthquakes, even though it was fertile land on a river. When the Spanish arrived, they started building there, and that city was flattened by earthquake 5 times in the 18th century alone. And then the Spanish kept rebuilding. The Spanish also built Spanish styles. They had solid walls, they used tiles, they took the storehouses of grain, And so when the big earthquake happened in 1970, the society had 500 years of vulnerability preparing it to be devastated by this earthquake, plus massive population growth. And so that led to the conditions of vulnerability. And so it's not the entire story, but I think what Benoit is arguing would be, and I'd agree, is that we need to look at the prevailing circumstances, be it an impact of an earthquake or migration from climate change, allegedly. Yeah, I think this is often missed out. And it's worth also just adding that it's no coincidence that when we hear about climate migrants, it's never from Germany or from Scotland to England, which would make a lot of sense, actually, because Scotland's very cold. But it's always from so-called developing countries, right? So-called global south countries. So we've already pre-selected a political economic context in which there is a high rate of vulnerability, and in the contemporary world anyway. And so almost when we choose case studies from countries that already have some political economic issues that are not shared by, say, Germany, then there's already like a selection bias in it. And so as a consequence of that, the non-climatic factor is often removed. We don't see it, but it is there. It's in the way we frame the problems we look at.
If I may just add something on so the fact there are many factors doesn't mean that some of them may be more or less important. What I find very interesting is that, and we keep forgetting that when we speak too much about climate change, despite climate change, the number of people in absolute numbers or in proportion of population would die in disasters has never been as low as today. It has been decreasing steadily over time.
Proportion or hard
proportion
numbers?
And absolute numbers.
Really, even though the population's gone up?
Even if you look at particular types of disasters, even if you look at weather event disasters, the number is decreasing clearly over time. Take the Philippines, 2 huge hurricanes or typhoons in Tacloban, a century apart. The first one, 5,000 people died. The second one, I think 50 people died, the same strengths.
And a bigger population now than then. Yeah.
So, I mean, what determines the number of people who dies or are affected by disasters is little bit climate change and a lot the response measures at the place where it happens.
Yeah.
I want to say warm thanks to our 2 speakers, who I think of very much. Thank you. These are their rewards. I want to thank them very much for a very enlightening, engaging, and interesting talks and discussion, explorations. For example, I think it's all kinds of ideas occurred to me as a result. One of them is perhaps you should become an advisor to the Dutch farmers and develop the concept of victims of climate judicial activism. Or maybe thinking of your discussion of the law of the sea institution and its appetite for more cases, and therefore its willingness perhaps to be indulgent in granting standing. Perhaps you and I could get together and develop the concept of green mail in relation to this, in which we would get standing to sue, and then various institutions would pay us to go away. I mean, obviously, the way the law's developed in lots of ways opens avenues for profit for entrepreneurs of much more lowly qualified people than ourselves. But anyway, I want to say thank you very much indeed. I think you will agree we've had a civilized, interesting discussion. It's made us think more deeply about some things, but we've also enjoyed it very much indeed. Thank you so much.